as the moderator for this webinar. Very quickly, I wanted to say that we're really excited for the start of our second year of this monthly series, and we've got some awesome topics lined up. In February, we've got Scott Hensley of Stansel & Company, CPA firm, speaking on individual and business tax planning. Many of us think about taxes only once a year, and Scott will share with us how making a plan for your taxes can help you take advantage of provisions, credits, and deductions legally available to you. I'm going to put the link to register to that webinar in the chat, so you should be able to see that. Also in March, our webinar is going to feature our first ever after-hours Meet the Presenter here in Raleigh. So we'll have Walt Brown, who is a full-time EOS traction implementer. He has helped some of Triangle's savviest business owners implement a system to build a better business based on how, and will be speaking with us and giving us some tips on how you can do that. So I'm going to put the link to register for that webinar in the GoToWebinar panel as well. And there's another link that will come your way on more information on the event. So that one's going to be cool because it's going to be a webinar. Then we're going to follow it up with a live event after hours. So we hope to see you there. But now back to this month's webinar. If you have any questions during the webinar, just type them into your GoToWebinar panel, and I will field these to the presenter. And at the end, we have some time carved out for a brief question and answer session as well. So we're really excited to have Mimi Soule, who is an employment law attorney and owner of Soule Employment Law here in Raleigh, back with us today. Mimi founded her firm to provide preemptive employment law and HR consulting to business owners and managers. She specializes in helping her customers avoid legal risks, protect their businesses, and reduce employment costs. We received so much great feedback from her first webinar that she did for us back in July of last year that we promised that we would have her back to further talk, give a little more information on employment law. So I highly recommend watching her first webinar, which I will also post as a link to in the GoToWebinar panel. It is a ton of great information, and I think Mimi's going to take us through just a little summary of what she said in that first piece. So without further ado, Mimi, I'll turn the floor over to you.
Thanks, Eric. I'm absolutely flattered to be asked to come back, and I hope that I don't bore everybody too much today. We do have a lot of information to go through, so unfortunately we will be kind of covering it at a 30,000-foot view. If people have specific questions, please feel free to email those to Eric, and then after the presentation, if there are further questions, feel free to email me directly. As Eric said, before we dive into our exciting topics today, audits and complaints at the Department of Labor, I do want to mention briefly the previous presentation, and I think that Eric is going to be posting a link so that you can go back and look at that listen to that presentation. The reason I bring it up is some of the matters that we touch on briefly in this presentation are discussed in a lot more detail in the last one. And just as a very, very quick summary, in my opinion, the best defense that an employer can have or business owner can have to any Department of Labor audit, any complaint at the Department of Labor, starts with whether or not you've properly classified your employees. And the two primary classification tactics are whether or not you've properly classified workers as employees or independent contractors. And once you've properly classified them as employees, have you then further classified them properly as exempt employees or non-exempt employees under state and federal wage and hour laws? Essentially, that plays into whether or not overtime is due and owing for certain employees who work more than 40 hours in any work week. One key thing that I do want to bring up is that one primary error that I see a lot of business owners make is an assumption that if they pay an employee a salary, that means that the employee is exempt from overtime. Unfortunately, that is a big misconception. Paying an employee a salary is just one element that you must satisfy in order to establish that an individual is exempt. There are additional duty requirements, so you have to establish that the employee fits and meets all of the required duties under the exemption as well. So as a starting point, one of the things I stressed in the last presentation was simply assume that all of your employees are exempt, or I'm sorry, assume that all of your employees are non-exempt and entitled to overtime, unless you've analyzed the position and you have proactively determined that they fall under an exemption to the state and federal wage and hour laws. Okay, so enough of that. I do recommend that you guys go back and listen to that if you have questions about either of those two classification tactics. And if you have, again, additional questions, feel free to email me. So without wasting anybody's time, I want to dive into our exciting topic of today. I'm sure you're all thrilled. As you can see, the first slide here is of an unhappy baby, and unfortunately, a lot of my clients, when I talk about audits and complaints, that's the reaction that I get. So if that's how you feel, know that you are not alone. And I hope that this presentation will offer you information so that if you ever are contacted by the Department of Labor and notified of an audit or a pending complaint, that you'll feel a little bit more in control of the situation and prepared. Okay, so let's start with Department of Labor audits. So the first question I usually get is, why is it that I've been tagged for an audit? And typically it's one of two things. One, either an employee that you have recently let go, or an employee that has recently perhaps voiced a concern about wages to a supervisor or a manager. And that employee has gone to the Department of Labor and they filed a complaint with the Department of Labor. So it's often based on that individual complaint, the Department of Labor has sort of flagged you as a potential audit. The other common answer to that question is really just some industries, unfortunately, have a well-known pattern or practice of not paying wages in accordance with state and federal law. Often those industries, at least right now, what I'm seeing, those industries the Department of Labor has pinpointed are the hospitality industry, and restaurant owners, hotel management companies or owners, even some resort type facilities as well. The other industry I'm seeing is a lot of is the construction industry. These are two industries that have a lot of rotating employees coming in and coming out, and like I said before, have unfortunately a history of not paying wages in accordance with the law. Now, I'm not singling anybody out, but that just happens to be a very general statement. So the reason you may be hit with an audit typically falls into one of those two categories. Often, the way you are apprised of whether or not you've been selected for an audit is you'll get either a telephone call or a letter from a Department of Labor auditor. Often you will get a letter. The letter will usually indicate whether or not they're going to proceed with what we call a desk audit or move forward with an on-site audit. A desk audit is really a request. They'll provide you with a request for certain records that they want to review. Usually those records are your payroll records, timesheets, a record of overtime payment and payments of any other types of wages, commissions, that sort of thing, tax deductions taken out of those. So they'll provide you with a list of the records that they want to review. Once you provide that information to them, then the second step is, after their review of that information, is often the on-site audit, where they want to come to your office and meet with you one-on-one, discuss any questions that they have about the information you've provided. Perhaps they want to review additional information that they feel that you'll have there on site, as opposed to doing another request for records. In certain situations, and in my experience, it's been situations where the auditor felt like it would be more appropriate to do an on-site first. Those are situations where sometimes they don't feel that the business owner is going to have adequate records in response to a formal records request. These are usually small business owners. As Many of you may be, you may have less than 10, 15 employees. As a small business owner, often we don't have the same formality in terms of how we document matters with respect to our employees. So often, the reason that a Department of Labor auditor may skip the initial desk audit and move straight to the on-site audit is because they feel that there'll be more information they can obtain from a business owner verbally than actually reviewing documentation. Either in the letter that you get from the Department of Labor or in that initial phone call from the Department of Labor, they'll typically tell you what the scope of their audit is going to include. When we talk about scope, the first thing we talk about is the length of time involved. Most of the audits that I've seen go back 2 years in time, so 2 years from the date that the auditor contacts you, going back in time. In terms of records, sometimes the audit specifically focuses on one issue. So let's say payment of overtime. It may focus on payment of wages to one particular group of employees. Sometimes, and I think more common, what's more common is the scope is really broadened. And the Department of Labor is looking for anything that you may, or they're looking for anything that they feel you may not be doing accurately with respect to wage payments. So if the scope is that broad, it never hurts to ask the auditor if they're looking for something in particular. They're not bound to or required to tell you if they're looking for something in particular, but sometimes it doesn't hurt to ask. And the reason I say that is that if you can figure out what they're looking for, and then you can conduct your own self-audit and determine what the issue might be, then it's much better for you to go ahead and create some sort of proactive plan on how to correct that issue and present that plan to the auditor. It's far more beneficial to address it that way than to wait until the Department of Labor comes in and does their audit and makes their own determination of what the issue is. So it never hurts to ask, and sometimes they're more forthright in telling you what the particular issue is. Once they evaluate the information, what they'll typically start with is they'll issue a letter advising you of what their assessment is. They'll highlight any violations that they believe that you have committed over the last 2 years, and they'll have a requirement of how they believe you need to handle these matters. Often, and one of the most common issues is simply we haven't paid wages accurately. For example, I had a client not too long ago that paid employees over a 2-week pay period, and unfortunately, he was averaging the hours over the 2-week pay period. So if the employee on average, or looking at both pay periods combined together, did not work more than 80 hours, then that employee was not paid overtime. Well, you have to look at overtime hours worked in each work week. So if in the first work week, they worked 42 hours, and in the second work week, they worked 38 hours, even though combined together it's 80 hours. In that first work week, they're entitled to 2 hours of overtime. This was the error one of my clients was making. So in that type of situation, Department of Labor will require that you settle and essentially pay back wages to all of the employees who may have been entitled to overtime pursuant to their audit. The other piece here is sometimes, as part of their audit, they'll determine that you may not be maintaining documentation in accordance with state law. In addition to payment of any back wages that may be owed, they may and could assess civil penalties as well. So, for example, in North Carolina, you're required to keep copies of payroll records for a 3-year time period. So if you don't have payroll records, then they can assess additional penalties. Usually those penalties are somewhere between $250 per employee per violation, and those can range from $250 all the way up to $2,000 per issue. I really can't give much explanation of how the exact penalty amount is determined. It's in the discretion of the auditor. But typically, I see those types of penalties closer to the $250 range.
And Mimi,
yeah.
and I think we discussed this yesterday, and it's something that makes sense, but was kind of hadn't really thought through. But if an employee complains and the Department of Labor comes in and says, "Hey, you're not paying this person overtime properly," then really you're on the hook to go back for 2 years for all employees, current and prior, and fix that issue. Correct?
Correct. I mean, that's essentially the door that these audits walk in through, and that's just one employee complains to the Department of Labor. The Department of Labor contacts you to settle that one issue and handle that one issue. And then as part of that investigation, they say, you know what, we want to see your records for all of your employees for the last 2-year period. So yes, that's often how we end up in an audit.
And here's a question that came up, and I'm assuming the Department of Labor is a state agency, so obviously each state is going to be a little different, but for those of us who have employees here and in other states, then that request can come from any of those states, obviously, and I'm assuming there's differences in penalties and whatnot from different states, correct?
Correct. Yep. Right. My familiarity is here in North Carolina with the North Carolina Department of Labor, but you're right. There in each state, there's typically a state agency, whether they're referred to as the Department of Labor or not. There is a similar state agency that handles state wage and hour claims, and the penalties and those can absolutely be different under state law. Great question. All right, the last couple of things I want to touch on very quickly. If the Department of Labor essentially arranges a settlement between you as the employer, the business owner, and the various employees who the Department of Labor determines you have past wage or back wages to, the settlement document will have a release statement in it. So it's releasing you as the employer from any additional liability with respect to the wages owed from these employees. Now, what I want to clarify here is the release only covers the specific issue covered in the Department of Labor's investigation, and it doesn't cover any future claims that employees could bring. So if there are other claims that an employee could possibly bring against you as the employer, it doesn't waive their right to bring those claims. So I just want to mention that briefly. And the last piece here is, and I'm going to just touch on it, it's very rare, but the Department of Labor does have the authority to seek criminal prosecution against business owners that it believes business owners who it believes are intentionally trying to avoid paying wages in accordance with the law. Very rare. I've never seen that actually in place myself, but it is there in the statutes. And the last piece here is, in situations where a business owner may refuse to follow the directive of the Department of Labor following the audit, the Department of Labor does have the ability to go into in front of a judge and have a judge order the business owner to follow the directive of the Department of Labor. So I mentioned those two things. I mean, I don't know about you all, but usually if the Department of Labor tells me I need to do something, 9 times out of 10, I'm probably going to follow their directive. So for those of you that don't fall into that same mindset, then an injunction or criminal prosecution may be a valid bullet point here. All right. Shall we move into what I think is your primary best defense here, and that is this. If you ever are contacted by the Department of Labor, whether it's by telephone or you receive a letter, my opinion is the very first thing you need to do immediately is conduct your own self-audit. Start with, classification issues. Have I properly classified my workers as employees? Look at your classification of exempt and non-exempt status. Have I actually gone through and determined that these employees that I'm treating as if they are exempt are truly exempt under the law? And do I have documentation of my analysis. So can I go back and prove to the Department of Labor that I actually thought through and went through, a test to make my reasonable determination that this employee falls into one of the exemptions. And then the last piece here is take a look at your own time records. So make sure that you have accurate time records from all your employees that reflect all of their hours worked. Make sure that you can review all of your wage payment. To make sure that, unfortunately I have some clients that call me and say, I'm being audited and I paid this employee out of, the cash box. So I don't have proof that I paid them these wages. So highlight any of these issues. Go through and do your own audit. Make sure that you have documentation of all wages that you've paid. If, as part of that review, you determine that there are some corrections that need to be made, and going forward, and that you feel like you have some errors that need to be looked at going backwards, then go ahead and proactively document those matters. Don't try to correct anything retroactively, but document what you have determined by your own self-audit, and then if there are changes that you need to make going forward to correct the payroll errors, then go ahead and make those changes going forward. And then one other thing to add to your audit, go through and review all of your payroll-related employee policies. Often these are found either in your employee handbook or sometimes just procedural guidelines that you may have for employees. These include your timekeeping policy, what you're how you're instructing your employees on how to input their time, whether they're filling out paper timesheets, whether they're entering it into some sort of website system that you have in place. But make sure that your policy on timekeeping is accurate. And one piece here I'll mention briefly, what the Department of Labor really likes to see in a timekeeping policy is that you have something mentioned in that policy that tells employees who they speak to if they have any concern about their paychecks, if they have any concern about whether or not they've been paid for all hours. So if you have a timekeeping policy, go in your policy and make sure you have something in there that instructs employees to come to HR or go to their direct supervisor or whoever the appropriate person is to notify them of any errors in their payroll and potentially errors in the timekeeping system. That was sort of a reference to bullet 2 there. The other piece to look at is your overtime policy. Make sure that you have a policy in your handbook that advises employees that if they're non-exempt, they are entitled to overtime. Paydays and practices. This is a state law requirement. North Carolina law says that we have to advise our employees in writing of when they're going to actually get paid. In North Carolina, you have to pay your employees at least once per month. Most small business owners pay twice a month. Eric, I think that you indicated to me that you guys pay on the 15th and the 30th of each month. That's perfectly fine. So as long as we have a policy in place that adequately tells our employees when their paydays are. So go back through as part of your audit and look at any related payroll policies. If you determine that those policies are vague or that those policies are unclear, go ahead and proactively correct them and put those new corrected policies into play. Once you have completed your audit, you've documented any issues that you think you may have, you've conducted your review of your policies, you've made any changes. Once you've done all that, take all of the records and compile them for the auditor. Here's what I mean by that. We want to make the auditor's experience as easy as possible. So at the same time, we want to control the information that we provide. So if the auditor asks for copies of your policies, I would not advise that you provide them a copy of all of your handbook policies. You only provide them with the policies that they've specifically asked for. Same with payroll records. If they only ask for payroll records with respect to a certain group of employees, only provide them with that information. Don't give them a report that has information related to other employees outside of their request. So we want to be cooperative and provide them everything they need, but we don't want to give them additional information in which they may find other errors. So we want to somehow control the amount of information that we provide. The other piece is this. What I would suggest, if you have an on-site audit and the auditor asks to review information, my advice would be don't bring the auditor into your office in front of your computer and allow them and open up your files and allow them in. If they ask for specific information, download that information onto a thumb drive perhaps and provide them with a thumb drive. So in that way, we're controlling the information we're providing at all times. The last piece that I'll mention here is this. If as part of your self-audit, you determine that there are some things you're not 100% sure about. You're not 100% sure that you've classified employees correctly. You're not 100% sure that there's an issue with how you're paying overtime. Before the auditor comes in and does their audit, my advice would be to go ahead and contact your attorney. One of the primary questions I get is, should I have my attorney present at the audit? And my take on this is, in my experience, a better use of legal counsel is to get your attorney involved on the front end to help you come up with that proactive strategy to address any issues that you've determined in your self-audit, so that you can take that strategy when the auditor comes in. You as the business owner can present that to the auditor. Sometimes, and I'm not trying to say anything ugly about my fellow attorneys, but sometimes when we get involved, government agencies they're not thrilled, and we often have some methods of communicating with certain government agencies that may not be perceived as pleasant. So in my experience, usually an auditor is going to work more favorably with a business owner directly than if I, the attorney, am standing in the room with the business owner. So in my opinion, seek legal counsel as part of your audit prep as opposed to having legal counsel at the audit with you. Eric, did we have any questions we need to address here before we move on to the next section?
Yes. How long do you think, well, in your experience, how long does one of these audits normally take?
An on-site audit, I've seen them take an hour, and I've seen them take, 2 days. It depends on the scope of what they're looking at, how many records they have to review. In terms of the entire audit process, from the time that you provide the information to the Department of Labor until the time that they make an assessment, again, unfortunately, that varies. I've seen them make an assessment within 2 weeks, and then I've seen them wait over a year to make an assessment. That, I think, is rare. I would say, on average, in my experience, it's somewhere between, 2 weeks and, I would say, 60 days.
Mm-hmm. Mm-hmm. And then I got a question about the penalties. I mean, what do you see? I mean, are we talking $100 an occurrence, or are we talking $10,000 an occurrence? What do the scope and scale of these penalties normally look like?
Yeah, most of the penalties have to do with record-keeping requirements and violations of that particular statute, which is usually failure to maintain things like a record of all hours worked, so timesheets. And those penalties range anywhere from $250 per employee per violation, all the way up to $2,000 per employee per violation. Typically, in my experience, the penalties I've seen have been closer to the $250 number. But it is within the discretion of the Department of Labor to determine, in their opinion, where they feel the proper penalty amount live.
Gotcha. Excellent. All right, thank you.
All right, so why don't we dive into the next exciting topic, the complaint process. And the kind of first thing I want to dive in and talk about is, several of you may be familiar with complaints that employees bring before the Equal Employment Opportunity Commission. And so the question I often get is, what complaints are filed at the EEOC and what complaints are filed with the Department of Labor? Typically, the EEOC is going to handle complaints of discrimination or retaliation based on discrimination matters. So race, age, sex, disability, veteran status, those types of things. At the Department of Labor, what they're going to handle are complaints about wages owed. So if we, let's say, some of the most common ones are failure to pay overtime. That often is a result of not classifying an employee correctly as a non-exempt employee. Often it is failure to pay out accrued vacation upon termination.
And can I ask a question on that?
Sure.
So my understanding, and from personal experience, that if you don't say anything, then you owe all of the accrued vacation. But you can stipulate in your employee manual that, okay, a maximum of 40 hours will be paid out. Is that correct?
That is correct. This is a state-by-state issue, and you are correct. That is the law here in North Carolina. So in North Carolina, if you do not have a written, it has to be a written policy. If you do not have a written policy that tells employees that they will not be paid out any of their accrued vacation, or that you'll only pay out up to a portion, that if you have no policy in writing, then yes, accrued vacation is considered wages and must be paid out upon termination. There are a couple little caveats. You do, as the employer, have the ability to put limitations. So again, Eric, in your example, you can state the company will only pay out up to 40 hours of accrued vacation upon termination. Or you can have other types of limitations. The employer will not pay out accrued vacation if the employee is terminated for any policy violation. On the flip side, your policy could state the company will pay out accrued vacation if the company terminates the employee without cause, for example, a layoff. So you as the employer have a lot of control over how and when you pay out, or how you pay out accrued vacation. But your policy has to be very clear on how it's paid out or if it's not paid out. Anything that can be interpreted as vague, if it's challenged at the level at the Department of Labor, the way the Department of Labor is going to view it is, what would a reasonable employee believe the policy to mean? And if it can be construed in favor of the employee, in my experience, 9 times out of 10, that's the way the Department of Labor is going to rule. So you can have that caveat. The only other thing I'll mention is this. I'm sure several of you do not have separate vacation and sick leave policies, but you have a combined PTO policy, paid time off policy. If you have a combined PTO policy, then you would, because you've got vacation involved in that PTO payout, then you need to treat your PTO the same way we would treat vacation, paid vacation under the law. The reason I bring that up is sick leave, paid sick leave, does not have to be paid out upon termination. So if you have a paid sick leave policy, whether or not you have a written policy or not, that is not included as wages under North Carolina law that have to be paid out upon termination. Great question, Eric. Anything else along those lines?
Nope, that was it. So the key point there is just come up with your policy and document it so you don't get surprised later.
Exactly, exactly. So at the Department of Labor, you're either going to have complaints regarding failure to pay wages, or you're going to have specific retaliation claims that fall under the North Carolina Retaliatory Employment Discrimination Act. And those, the three primary there are wage and hour retaliation. So an employee has made an internal complaint to you that you haven't paid wages accurately, or they file the complaint with the Department of Labor, and after they submit either of those complaints, we discipline them or terminate them. Workers' comp retaliation. So an employee files a workers' compensation claim, and shortly after that claim is filed, we discipline or terminate them. Similar situation with OSHA safety complaints. So an employee internally or externally makes a complaint about a safety issue, and not long after that, we make a disciplinary action or take disciplinary action or terminate them. So those are the types of complaints that are filed with the Department of Labor. So once a complaint is filed, you as the employer will receive a written notice that the complaint has been filed. In that notice, it will provide you with usually a very short summary of the complaint that's been filed, and will ask for what I refer to as a position statement, but essentially it'll ask for your written response to the complaint. So if you look at the far right where I have position statements, there are three pieces that I think are very important when you put that written response together. The first piece is what the Department of Labor is looking for is more of a fact-driven response. I draft these for clients, and often I include some legal support, which helps, but the primary piece that they're looking for is really the facts. So they want to know from your perspective, what happened. So if this is an employee that's claiming that you failed to pay overtime, they're looking for a response from you with some proof that you've paid the employee for all hours worked. So the two ways that you prove that you've paid all hours worked is by having supporting documentation. So do you have timesheets and payroll records that match and that reflect all hours that the employee, that you've paid for all hours that employee has worked? And then the primary piece I see that's often left out by business owners is what I refer to as comparators. So I'm going to give a different type of example. So let's say you have a workers' comp retaliation complaint that's filed. And one way to show that you have not retaliated against an employee because they filed a workers' comp claim, one way that you can establish that and provide some proof of that is by looking back over, let's say, the past year or 2 years and pulling out all of the employees that have filed workers' comp claims. And if you have not disciplined those employees or terminated those employees, then that establishes a very strong argument that this particular employee who filed the complaint, with respect to that employee, that you haven't treated that employee any differently than anyone else, and that the true reason that you took the particular disciplinary action is because of, let's say a performance issue. So in addition to having the documentation about that performance issue, you can also show by using comparators that you haven't treated this employee any differently. So those are kind of the three pieces that I think you really need to focus on when you write this written response or this position statement. So in addition to asking for your written response, the Department of Labor may also, whether that's before they get your response or after they get your response, I think typically it's after, they may ask to do witness interviews. In my experience, most of these interviews take place over the phone, and the Department of Labor does have the ability to contact your employees and interview them directly. Now, with respect to managers, you have the right as the business owner to actually sit in on that interview. You don't have the right to say anything and intervene on behalf of the manager or answer on behalf of the manager, but you do have the right to listen to the interview. So those are kind of the key pieces to the Department of Labor process once you receive notice of a complaint. Just a question of that.
Mimi, if a position statement, so of all the complaints that typically come in, a well-written position statement, is that going to do away with, what, half of those complaints, a third of them? And what's kind of your experience if you do a really good job in this step?
Sure. I'm going to just click to the next slide here. So what typically occurs is this. Once you submit your position statement, then and once the Department of Labor finishes its investigation, then they're going to issue a determination, and it's either a determination where they say that there is merit to the complaint, meaning that they feel that the business owner has done something improper, or it'll be a determination that there's a no merit finding, that they don't feel that the employer's done anything improperly. Either way, whether there's a merit finding or a no merit finding, just like with the EEOC process, they're going to issue the employee what's called a notice of right to sue. So even after the Department of Labor issues their determination, the employee then will have a right to pursue a lawsuit against the employer. So to answer your question, Eric, what I see in terms of what does the drafting a good position statement do, an effective position statement? What you want as a business owner is a no merit finding. And so in order to get a no merit finding, you need a very well drafted written response position statement. And the reason you want a no merit finding is this. Often with the no merit finding, the employee then is going to get that letter, and then the employee is going to try to take it to an attorney to have an attorney assist them with a lawsuit, assuming they want to push the matter forward. Well, I can tell you that most attorneys would much rather have a client who's got a merit finding than a non-merit finding. So it will make the process a lot less, or it'll make the likelihood of an actual lawsuit being filed a lot less if you have a no merit finding. The other piece to it really, plays, unfortunately, drafting a well-written position statement will not terminate the issue of having a lawsuit filed. However, having that information already in writing, and in writing in a very clear and concise manner, will help you if you do have to hire an attorney to represent you in that matter. And the way it helps you is this. It makes the attorney's time reviewing the matter a lot more efficient. The more efficient you can help your attorney work, the lower your legal fees. So it can actually help you in a couple of different ways going forward. Does that answer the question, Eric?
Yes, perfectly.
Okay. How are we on time?
We're coming up on it, but I mean, this is good information, and our attendees are still hanging with us, so you roll on.
Okay, so just a couple more points here to finish up the discussion on the complaint process. So as part of the Department of Labor's determination, they may come to you and ask if you want to participate in the conciliation process. This is kind of like a mediation or a conference. Essentially, they want to sit you down with the employee across the table and figure out if there's some sort of settlement that we can come to. Now, usually as part of this settlement, what the Department of Labor is looking for is generally two things, or one of two things. If you've terminated the employee, often the Department of Labor wants to have that employee reinstated. So they may be looking for reinstatement and asking you to bring that employee back on the job. The second thing they're looking for is some sort of payment for what they'll classify as lost wages or the value of any lost benefits. So as part of your process, in terms of agreeing to sit down and mediate or participate in this conciliation, if you're not willing to bring that employee back to work, if you're not willing to pay out some sort of settlement amount, then that conciliation process may not be the best use of your time. So it's not a bad process if you feel that maybe you did make a slight error and you do want to pay something out a little bit, or if you like the employee and you don't really have a problem bringing them back to work. If that's the case, then I think the conciliation process is quite successful. Here's the primary risk. If an employee files a lawsuit, so we go through this whole process, the employee receives their determination letter and their notice of right to sue. Once they receive that letter, they have 90 days from the date of that letter to actually file a lawsuit. So if they file a lawsuit, and guys, I'm thinking worst case scenario, worst case, they are successful in their lawsuit, then the risk to us is the damage piece. So, and I'm going to give a very simplistic example. Let's say that it's, again, a failure to pay overtime. And that overtime amount, let's say, was $1,000. Well, if the employee wins at trial, then not only will we be required to pay that $1,000, but the judge could order that we actually pay 3 times that amount, plus the cost of bringing the matter to court, which could include the employee's attorney's fees. So sometimes, if we think about what the potential risk could be and what the total amount of damages could be, it may make more sense to talk settlement on the front end than to push the matter all the way through to a trial. So I think that is the end. I hope no one has fallen asleep. And if I can answer any other questions, please let me know. If anyone has sort of a form position statement they put together, I'm happy to take a quick look and give you my thoughts. If anybody has questions about an upcoming audit, I'm happy to give you my thoughts on how to prepare. So please feel free to touch base if anyone has specific questions.
Awesome, awesome. So a couple of points just in summary, at least what I took. Do an awesome job on record keeping. Make sure you have your policies and procedures communicated. If you do get an inquiry from the Department of Labor, make it easy on them. Give them the information they request. If you find something that you've done in error, go ahead and fess up to it. And then if you need to present a position statement, then make sure you use those comparisons and explain to the Department of Labor other times this has happened that you haven't done the same actions.
That sounds good.
All wrapped up. So yeah, we've got a couple of questions. Let's see. Overtime. So here's a question, and I know this has come up in our business as well. If you have an employee who's paid hourly and they have overtime that wasn't approved or that you didn't tell them to work, you still have to pay it.
Yes, that is the answer. So unfortunately, as the employer, our obligation is to pay employees for all hours worked, even if we haven't approved those hours, even if we have a policy saying that employees have to obtain our approval before they work those hours. All we really can do in that situation is we can discipline the employee based on their failure to follow our policy. So unfortunately, we are required to pay out that time, but we can't discipline for failure to follow the policy.
Excellent, excellent. Now, in two quick point, a quick point and then a question on overtime. I know we pay 15th and 30th. In your example about the overtime being based on a weekly basis, a lot of times you get into a case where you need to carry over hours. So our pay period may end on Wednesday, and I need to take the hours from Monday and Tuesday and Wednesday into the next pay period to calculate overtime for that week, correct?
Correct, yes.
Excellent.
Yep, you have to look at it over a work week basis. That's true.
Gotcha. Okay, and then so the next question kind of goes along with that. With the ACA, health insurance eligibility is a full-time employee is considered 30 hours. What's the difference between that and a 40-hour work week? Well, how does overtime impact that?
So I've actually gotten that question a couple of times, and the answer to that is this. Even though the Affordable Care Act may define a full-time employee at 30 hours per week for purposes of their eligibility for health benefits, from a standpoint of wage and hour, overtime payment, overtime still kicks in only at 40. So if you have an employee that works 30 hours typically, and 1 week they happen to work 32 hours, those 2 additional hours you just have to pay straight time. You don't have to pay them at the overtime rate. If they happen to work over 40 hours, then once they hit that 40-hour mark, then overtime is due.
Excellent. Excellent. All right, listen, a couple of things just real quick. One, Mimi, thank you so very much for coming back. Every time you come, I learn a couple of things that I've been doing wrong, and so that's always helpful for me. It's like free legal advice.
Good, glad to help.
And secondly, I realized I failed to mention our sponsors. That's us, Reach Commercial Realty, and Insperity. And thirdly, I'm going to shoot out the link to our webinar series on our website. go there, take a look. We've got 2 awesome webinars coming up. And also all of our past webinars are recorded and posted on that web page. So everybody, please take a look at that stuff. And Mimi, thank you again, and have an awesome day.
You're so welcome anytime.